Professor Andrews, good to see you. Thank you so much for speaking with us.
You're welcome.
So complex judgments essentially handed down by the Supreme Court today in both the Congressional cases and the Manhattan DA's case. Main takeaways, and perhaps start, I think, with the ruling that the president did not enjoy absolute immunity as it pertains to that grand jury criminal investigation in New York.
Yes, absolutely. So with respect to the New York case, the New York District Attorney sought some information. There was a subpoena involving the Trump presidential campaign and the idea of paying off certain women, which would have been a violation of the campaign finance laws. So the subpoena sought to obtain information from the banks and other financial institutions. They didn't go to President Trump directly. They sought the information from the financial institutions in order to ascertain whether the campaign financial laws were violated, because these were payoffs to women that the president allegedly had affairs with, Stormy Daniels and a few other women.
And essentially the court ruling against Trump's lawyer's argument that the president enjoyed absolute immunity. That's a critical takeaway in that DA case, right?
It's a critical takeaway because the president's attorneys argued that as president of the United States, he had absolute immunity while he was in office. And the court rejected that because under two prior cases, important landmark cases, the Nixon case, in which President Nixon tried to hide or he did not want to disclose the tapes in the White House, and the court there ordered him to and said he did not have immunity, and that led to his resignation. And similarly, President Clinton tried to hide documents in the sexual harassment case against Paula Jones. And in that case as well, that were used in his impeachment trial. So there are precedents for this. What is remarkable about this case was that the two prior cases, the Clinton and the Nixon cases, the court was unanimous. In other words, the judges, whether they were quote-unquote Democratic or Republican, all unanimously agreed about the concept of presidential immunity. In this case, there were two dissenters, Justice Alito and Justice Thomas. And what's interesting is I haven't had a chance to go into line by line of their dissent, but their dissent is almost as long as the majority opinion.
What can you say about the decision related to the congressional cases, right? Essentially, they're saying you cannot have access to those financial records, those tax returns, and we're set for now, but we're sending it back to the lower courts for deliberation on this question of separation of powers. Explain that for us.
That's right. The question of separation of powers obviously is very, very important and the bedrock of the American Constitution and government. What the court is saying is they're not saying that the Congress never has the right to seek that information, but they must provide justification. And in the lower courts, the Congress have not demonstrated sufficiently justification for the subpoena. And one of the justifications is that it's required to enact legislation. So it was a defeat for Congress with respect to the here and now of these congressional hearings, but it's not a defeat with respect to the overall immunity and the right of Congress to seek, testimony and to seek documents from the president through a subpoena.
Professor Andrews, if you'll allow me, I just want to remind our viewers what these cases were about. You kind of touched on that a little bit, right? The congressional subpoenas were born out of three committee investigations. First, testimony from Trump's former fixer, Michael Cohen, who testified in Congress that Trump had inflated or deflated his assets on financial statements in order to reduce his tax burden. The other, it was into possible money laundering into property deals involving the Trump administration, the Trump organization, And the third investigation was examining whether Trump's dealings left him vulnerable to foreign influence. Then you have the Manhattan case, which relates, as you pointed out, to the hush money payments to two women who claimed that they had sexual relations with the president in violation possibly of campaign finance laws. You talk about the unanimous decisions in past cases. What do you make of the 7-2 judgments falling, given the partisan nature that this court is considered to be?
Yes, it's a pity that Justice Alito and Justice Thomas couldn't come on board, because when you look at the judgment, it is very interesting that Chief Justice Roberts wrote both opinions. And when you look at the decisions, it was clear that he wanted as large a group as possible to agree to the judgment. So it was pretty broad to ensure that Justice Gorsuch and Kavanaugh on the one hand and Justice Sotomayor and Ginsburg on the other could all agree. But I do believe that the unfortunate thing is that Justice Thomas and Justice Alito have so sort of tethered themselves to an ideological view that one can only assume that from their perspective, this president is entitled to absolute deference. What's very interesting about the case as well is that Justice Thomas thinks of himself as an originalist, as well as Justice Alito. And there's nothing in the Constitution that in any way provides the kind of immunity that President Trump had sought. So one can only conclude that the dissenters in both cases, as I said, have tethered themselves to an ideological vision, and in that they've smeared the court, because it is very important that the Supreme Court is above politics and sees itself as above the current polarization in the country.
Both sides here, Professor Andrews, are claiming victory. Speak to that. Who's won here?
Well, both sides have had victory, but for some it's a temporary victory. So for the president, it's a temporary victory. In the Manhattan DA case, the Supreme Court has said it goes down to the lower court. And the president still has the opportunity, as in every case in which there's a subpoena, to fight against the relevance and the details of the subpoena. So it's a temporary thing. Of course, the Manhattan DA has won on the legal principle, but practically it means that the president's financial records may not be disclosed to the American public for a very long time after the elections, maybe
certainly not before
2021. Yes.
Right.
And similarly with the Congress, the president has a victory here with respect to the Congress, but it's a temporary victory because the court has not said that Congress never has the right to obtain this information. The court has basically said you justify it before the lower courts, and you did not do that. So I think that, yes, both sides can claim victory, but for the rule of law, I think this is a victory. I think for President Trump, it's temporary, but as a practical matter, the American public will not see those financial records, certainly not in the short term. Now, if at the lower court the subpoena is actually justified and the president loses there and charges are filed, then the American public will be able to see the materials. But again, this is, we're 4 or 5 months to the election. The American legal process works very, very slowly, so it will be some time before the public sees this. So yes, both sides can claim victory, but of course the president has already sent out a flood of tweets.
I was going to ask you about tweets. Let me ask you about those tweets. The president claiming that these cases amount to presidential harassment, they are political in nature, that the Supreme Court has given other presidents broad deference, but not him. What do you say?
Yes. Well, he's wrong. He's absolutely wrong. It's not the first time that he's wrong. He's wrong on the law. As I said, the Clinton case and the Nixon case are precedents for the idea that the Supreme Court is very, very clear about the limits of presidential immunity. They've said the president is not above the law. And so he's wrong on the tweets.
Final question for you, Professor. What do you make of the notion that these cases could very well end up in the Supreme Court again?
They could, because the president's lawyer, Jay Sekulow, has already said that they will fight this tooth and nail down at the lower courts. So if they produce further constitutional arguments, this could really delay the trial, and it may make its way up to the Supreme Court and back, for some time.
Professor Andrews, thank you so much for your insights. I do appreciate it.
You're very welcome.
Professor Penelope Andrews teaches comparative, constitutional, and international law at New York Law School and is also the co-director of their Racial Justice Project.